Welcome. Thank you, Jared, for the introduction. Thank you all for coming out. Just continue to enjoy your lunch while I tell you a little bit about estate planning, wills, trusts, and how we can be good stewards of the resources that God has blessed you with. Again, my name is Jay Fellows, and I do come to you from Phoenix by way of Minnesota. I finally wised up and have been started the first 30 years of my life in Minnesota in the tundra. And yes, it is colder there, although driving from Bloomington out here, boy, it felt just like driving through small-town Minnesota, which is where I grew up. The last 22 years, my wife and I and two children have lived in sunny Phoenix. So I talked to my wife yesterday. It was 72 beautiful degrees down there, and I can't wait to get back there this evening. Grew up in small-town Minnesota, Lester Prairie. Do we have any former Minnesotans here? No? All right. Usually there's one or two. Went to a small Christian university in Minnesota called St. Olaf College. Some of you are probably familiar with St. Olaf. You may have heard of their choir. They're very famous for their vocals and their bands and their singing. And they told me, Jay, it's all right, you go play baseball. So they didn't want me to sing. They told me to go play 4 years on the baseball field, and so I did that along with 1 year of basketball. And then, after the cold hit us again and again and again, we made that decision to move to Phoenix. We live outside of Phoenix, a little town called Peoria. I know there's a Peoria, Illinois. This is Peoria, Arizona, and have, again, been down there for a couple of decades. Over the last 30 years, as Jared mentioned, I have been self-employed. I had a number of different businesses, and probably like some of you, about 6, 7, 8 years ago, the Lord really started nudging me to serve Him. And so one of the ways that I have done that is now over these last 2.5 years, I've done some work with Financial Planning Ministries, FPM, which you're going to hear about today. FPM has been around for about 35 years, serving churches, Christian colleges, organizations, financial organizations like CFR, and other partners under God's kingdom. We have about 101 partners at this point, and they fund our ministry. So each month, we are a Christian nonprofit. We are funded by these 101 partners. So it is partners funding us to do God's work, okay? So that's how we're able to do this ministry and not ask for anything from you up front to prepare documents, estate plans, trusts, wills, medical directives, different things like that. And we'll talk a little bit more about that. What you're seeing this morning will be done. We did it about 410 times last year, all over the country. We do this in, right now we're doing this in about 48 different states. And in my short time with FPM, what I've really fallen in love with is this partnership model that I described, that we have with the churches and these other organizations, as well as the vision and mission for biblical stewardship, which really kind of piggybacks on a little bit about what Jared shared with us just a few minutes ago. Because again, Scripture tells us in Psalm 24 that the earth and everything in it is the Lord's. So if you believe, as I do, that all we have been given, everything that we have ultimately belongs to God, and that we are just caretakers of those resources while we're here on this earth, then we'd better make sure to make plans for it, even after we're gone, even after we are in eternity with the Lord. And estate planning, which you're going to hear about today, gives us the opportunity to direct our resources to where we want them to go at the time that we no longer need them, when we have been literally relieved of our earthly duties. Now, if I can talk candidly, I'm quite certain that the topic of estate planning and wills and trusts and dying and all that fun stuff is not probably real prominent at the breakfast table or when you're out with friends for dinner. And we understand that. So one of our goals is really to just provide you with information so that when you walk out of here, You have gained some knowledge, and you know a little bit more than when you came in. We do not have anything for you to buy. There is not going to be anything as you walk out that you have to purchase. There's going to be no CDs that still do CDs? Maybe we don't. But we won't be handing any of those out either for you folks. Our goal is simply to be here in partnership with Christian Financial Resources and your church to provide you with information. All right? So we do have a fair amount of information because really the information is the information. All right? But I am going to try and make it at least a little bit lively and a little bit interesting so that you can get a feel for what it is but still stay awake at the same time. Let me start with the ground rules. First of all, unlike most folks that might give a talk, we actually encourage you to throw things, all right? Because before you guys got here, I set up an imaginary probate line, all right? And anything that crosses over that line into probate, I am now the judge. I get to keep a little bit of that. So if you're going to throw something in value, because I'm going to keep a little bit before I give it back to you. And we're going to talk a lot about probate and what that means to us when we pass. Okay? So that's ground rule number one. Ground rule number two is you're going to have some questions probably during the talk. All right? And if you do, just simply jot those down on a piece of paper. We probably will get to them. But if I don't, I will ask for some questions after we're done, and we'll do some question and answer, a little Q&A. And if it's something a little bit more personal or something that you might not want to bring up with the group, I'll stick around as well, and we can have a little sidebar afterwards. Additionally, I will be coming back in the next 3 weeks to spend a couple of days with you folks, and anybody that wants to sit down and chat one-on-one and potentially take this to the next step, which is preparing documents. So there will be an opportunity for us to gather as well for 45 or 60 minutes in about 3 weeks. And along that same lines, I don't know, because we ended church, you grabbed lunch, and you came in, the way that we communicate with you is through email. So I don't know, did anybody check off if they've signed in, or have we passed out a sheet? If we haven't, we just want to make sure and get your name, who was here, what your email is, and a phone number if you have it. Because the only thing we'll do is communicate with you about the appointments that are coming up. There's nothing else for us to sell you. We do not sell other items. We simply want to communicate if you're interested in setting up an appointment. So if you haven't done that yet, find the sign-up sheet, or if somebody has that, make sure that everybody's checked it. Is it done? Perfect. We're good on that. Awesome. And if you haven't, if you snuck in, then make sure to get on that sign-up sheet. And then lastly, again, from small town Minnesota, so the last rule, or the last request, I guess, I went to a little Lutheran church, all right? And our pastor, Pastor Walt, wonderful man, he used to say when he needed a little bit more than an hour, all right, when he needed just a little extra grace from the congregation, because again, this was a rural community. Many of them were farmers. Many of them had to get back out into the fields or into the barn or whatever it was. So when he needed a little bit more than an hour, this is what Pastor Walt would say. Now, folks, I understand that it's a fine line between a long, drawn-out sermon and a hostage situation, all right? But I promise you, we're not going to keep you hostage today. All right, but I do need a little bit more than an hour. It's going to take about 70 minutes. We're going to buzz through the information, then we'll have a little question and answer time. Understand if some of you have a commitment, you've got to step out. Totally understand that. All right, so let's get started. So when we think about passing on our assets, eventually to our loved ones, we can probably all agree that it would probably be a good idea to write that information down. Right? Instead of just talking about it at the Thanksgiving or at the Christmas table, it'd probably be a good idea to make our wishes known in some sort of physical form, a document, right? If we're going to do that, what's the most popular document that we're going to use? I heard it, a will, all right? Feel free to shout out answers. A will, the last will and testament. That is the most popular one. Our team, by the way, there's about 10 of us that get to do what you're seeing this morning. We travel around all over the country. Again, we're doing this in about 48 different states. And we always get that same response. Yeah, that seems like it'd be a good idea to write our wishes down. We should put them on paper. We should make it a legal document. Throw out some guesses for me. What percentage of us never get around to putting any of our wishes on paper? Anybody have a guess on what percent will pass from this earth to the next and not put anything down in writing? What would you guess? 80? Boy, I heard 90% of it. Negative Nelly. Not quite that high. All right. 55, very close. 65, yep. So we're right in that ballpark. Between 60 and 70%. We use typically around 60% to be conservative. 6 out of 10 people, whether they're believers or not, just in America, 6 out of 10 people will pass from this earth to the next not having put any wishes down on paper. All right, we know this because when that happens, it's automatic that your estate ends up in the process, the court process known as probate. Okay? Now, for those of us who do document our wishes, about 30% end up doing it in the will. Okay? A last will and testament. We're going to talk a little bit about that. But what most people don't realize is that it might not be their best choice or option. And many of you probably sitting here today have a will. And this is one of those things that we want to communicate to you, okay? We're going to talk about wills, and we're going to talk about trusts this afternoon. And you're going to start to hear that one of them has some particularly helpful and advantageous features about them. And again, we just want to educate you on the options that are out there so that you can make an educated choice, if you want to choose at all, okay? We think you're here because you probably don't want to be part of that 60% anymore, right? Let me talk about the question that's been staring at you for the last few minutes. Will your loved ones have to probate your estate once you are gone? And that's one of the main considerations that this comes down to. All right? You may feel that you have your estate set up in a certain way that is going to make life easier for you and for your spouse. But what we're really talking about, folks, is what is going to make life easier for those that are left once you and your spouse are no longer here. You have passed on. So part of being a good steward is making sure that we have those things in order, okay? As Jared talked about earlier, we want to be generous while we're here on this earth. But then what is going to happen when we pass from this to the next? What's that last stewardship act going to look like when that transition happens? We know as believers what our spiritual transition is going to be, right? We're going to leave this temporary earthly setting with all of its challenges, heartaches, decay, all of that, right? And we're going to an amazing home, right? A forever eternity with the Lord, our Savior. I mean, can I get an amen? It's going to be awesome, right? But what it comes down to while we're still on this earth is, will your loved ones have to probate your estate? And we would like to show you how to avoid that. And there are some things that you can do up front while we're still alive to help avoid that. All right? So let me circle back for just a second to the question I asked you a few minutes ago. If it was such a good idea to put our wishes down on paper, then why do so many of us just never get around to doing it? I mean, the last time I checked, are we in Tazewell County? Is that what I saw? Tazewell? Okay. In Tazewell County, probably similar to Maricopa County in Arizona where I come from, the mortality rate is still 100%, right? I mean, we are all going to die. So if that's the case, what is the reason? What are some reasons? Anybody have a reason that you either have not set something up or you feel that there's a reason that others haven't set these documents up? Anybody have a reason that you haven't done this yet? Yes, in the back. It's expensive, right? I mean, normally what it means is we have to go sit down with a professional, and that's going to cost some money to not only get it set it up, but also to administer it, right? And we know that if we make that commitment, now we got to update it And if things change, we have more kids or more grandkids or we move or whatever, now we got to go back and there's going to be more costs. So that can be definitely, we'll get to it next year or next decade, or when I finally start to get a diagnosis that I might not be around, then I'll do it, because then I don't care if I spend money. What else? A depressing topic. Well, when I'm done, you'll probably think the same thing, all right? It can be, right? We don't like talking about our own mortality. Who was it? I think it was Woody Allen that said, it's not so much I'm afraid of dying, I just don't want to be there when it happens, right? Talking about death, talking about this transition from this earth to the next, might not be the easiest thing to talk about, and yet it's important, okay? What else? Any other reason? Yes, ma'am. Yeah, so we have children. Do you have minor children? Yeah, so having kids and trying to figure out, if we're gone, who's going to raise those kids? Some of you, it's maybe real easy, okay? But for many of you, that's not an easy thing. Or who are we going to give stuff to? This kid's real responsible, and this one, I can't imagine. I give them $10 and they blow it, right? What if I gave them some real resources? What are they going to do with it? What else? Any other reason? Yes, ma'am. Yeah. So maybe we don't own a home, or we don't have land, or probably most of you sitting here are thinking, just as Jared pointed out, I'm not rich, right? I don't got much stuff. I don't own a home. But I think what you'll see as we walk through today, that we are all blessed with many things. And a lot of those things, when we start adding it up, really is something that we want to make sure that is passed on in the manner that we want. God has given those resources to us. How can we pass those on? All right? Anybody else have any other reasons that they haven't done it, or anything? Yes, Pastor Rusty. Yeah. Well, if anyone knows, you do, that Scripture tells us we're not giving anything past today, right? So, but that is the mindset, right? We're young. Why do I need to do this? And yet we're going to find if we have young children, getting something in place is a really good idea, legally, all right? And we're going to talk a little bit about those. Those are all excellent reasons. Another reason, our president, Mike Pryor, loves this slide. He took this picture in California, which is where we're based. We're based in Irvine, California. I work out of our Phoenix location, or I work out of Phoenix where I live. But in this picture, you'll see, if you can see it, it's got the gas line is still attached. We get busy. We get distracted. All right? And when that happens, things like this happen. And life just goes on, and before you know it, we haven't set this up. Now the kids are old or whatever, and so we get busy and distracted. So today, what we're going to try and do is just slow things down a little bit. All right? I want to talk about this in plain English so that it's understandable. All right? And again, so that when we're done, you feel like, wow, estate planning, wills, trusts, I have a better grasp and a better understanding of what that is. So you have a good idea of what it is that you should do moving forward. All right? So let's dive in. There are 3 options when it comes to planning your estate. Only 3. This is universal. So all of us will die, and all of us will have done one of these 3 things in regards to planning our estate. The first is intestate succession. So I just told you that I'm going to try and make this in good, easily understandable language, and what do? I throw out a legal term. All right? Does anybody know what intestate means? Dying intestate? No will. All right? So this is at 60 to 70% of people. I know it sounds like a gastrointestinal ailment, all right? But dying intestate succession, basically means you have no papers. And unfortunately, it is very common. All right? I know we're in the land of Lincoln, but our 16th president, who happened to be a lawyer, when he was assassinated, did not have any paperwork. He died intestate. All right? More importantly, or more recently, I'm from Minnesota. Some of you are probably familiar with about 2 years ago, this rock star passed with no records. Well, he had lots of records, lots of recordings, if you will, but he had no recorded documents. All right, everybody remember Prince? All right, Prince passed with nothing recorded. And now he's got an estate estimated somewhere between $250 and $400 million, and it's going to be fought over for a decade or more. All right. At last count, I believe someone shared this with me, that there are now 67 individuals who claim to be Prince's offspring. All right. Now that may be true. I don't know, how Prince worked, but when you don't have any documents, people can come in and make some claims on that estate. Also, recently, Aretha Franklin, the Queen of Soul, passed $75 million of estate value. A 72-year-old lady did not have anything in place. All right? So it is very, very common. The second option, if you can either die with nothing or you can have a last will and testament. Now, within this last will and testament, there are a couple of options. The first is a holographic will. Does anybody know what holographic means? Sounds like it should be like a video, right? All it means is handwritten. So why don't they just call it a handwritten will? I have no idea. But for many of us around the country, the reality is a handwritten note could be your last will and testament. Simply put your name on it, say what you want to say, date it, sign it, don't even need witnesses or a notary, and it is a legal document in 26 different states, so over half the states in the Union. Now, it's not a legal document in the state of Illinois, so don't get any ideas that you can just write out your estate today while I'm talking, don't listen, and I'll just be done with it. It is not legal in Illinois, but it is in Arizona, where I come from, and 26 states combined. So the question is, with something as important as this, do we want to just have a handwritten note, literally on the back of a napkin, is a legal document in those states? So why do we even mention this? Well, because we do want you to understand that, again, it is a legal form that the courts would recognize in over half of the country. Of course, just because it's an option doesn't mean it's the best option. And that's what you're going to start to hear today. There are many options of setting up your estate, but we want to look at what are some of the better ways to do that, all right? We think that makes a difference. The second type of will is a witnessed will. This is the more common type of will, where two people are signing, or three, or whatever it is in your particular state. In Illinois, it is two, all right? They're signing at the same time that we are signing, confirming that it is a legitimate process, that we are who we say we are. They know who we are, or they have looked at our identification. They saw us sign it. They are attesting to its authenticity. We do need 2 witnesses in Illinois. We need 3 witnesses in Vermont. And we need 2 witnesses plus a notary in Louisiana. And we think that might be because of Mardi Gras. All right? The third type of will is the outdated will. Anybody have that one? The outdated will? All right, I'm seeing some hands go up. Congratulations. All right. This is that will that was created 5, 10, 15, keep going, 20, 25, okay, maybe 30 years ago. And at the time, it was an accurate snapshot of what your desires and your wishes were. All right? Then you signed it. People attested to it in all likelihood. You folded it up, and it went into that spot where you keep all your important papers, right? And there it sat, and it continues to sit today. Because when you get right down to it, when do you need a will? When you die, right? Once you have passed, a will becomes a very important document. But while you're living, the last will and testament has no legal authority on your behalf. So if you want to write something down that is important to you, that you want people to pay attention to while you are alive, don't put it in your will. The will only takes place and takes over after we have passed. Then it can be a very important document, but not while we are alive. All right? Third option. So again, there are only three. The third option is you will have put together a trust. All right? And within the trust family, there are a couple of options. There is what's called the irrevocable or charitable remainder trust, or the revocable living trust. And there is a difference in the first word of each of those, all right? And when we put an IR in front of that word, right, for you English majors, it means not revocable, all right? So let me just talk about the first one real quickly, this irrevocable trust. It means it can't be changed, can't be revoked, can't be modified. And so it's usually a very specific situation that it's going to be used. Perhaps, I'll give you an example, maybe you have purchased some farmland, or maybe you made an investment in stocks or bonds or something like that, and over the years, that investment has appreciated greatly, or maybe you put some money with CFR and it's appreciated, just immensely, right? Amen, Jared. Hopefully it's increased in value, whatever that investment was, right? And when it comes time to sell that investment and take your profit, what does the federal government want to do? They want to congratulate you and say, well done. Now give us a piece of that. How do they do that? Tax. And it's called a capital gains tax, right? It's the difference between what you bought it for and what you sold it for is your profit. And they want to say, we should get a piece of that profit for you doing so well on your investment. All right? What we want you to understand is there are situations where a capital gains tax on that profit could be optional. All right? You don't necessarily have to participate in the capital gain if you have set up this option in, an example is, an irrevocable or a charitable remainder trust. Now, I'm not going to spend a lot of time today or getting into great detail about this, all right? But what we do want you to understand is that if you have real estate, you have land, you have an investment, securities, whatever that is, and it is likely to have a significant capital gain, and you are considering putting that asset up for sale, either now or sometime in the future, that you should consider or look at this irrevocable charitable remainder trust as a way to avoid those capital gains or avoid those taxes, all right? So, and that's something I'm sure Jared and his organization or Rusty or us would be happy to talk with you about. What I'm going to talk more about today, which is what applies to really the vast majority of us, is what's called the revocable living trust. All right? So the difference between the first one, irrevocable, and the second one, revocable, is the second one, the revocable living trust, is changeable, modifiable, amendable. You can cancel it. You can revoke it. You can do whatever you would like with it because it is revocable. All right? And to us, that's important because life changes. Right? Life is dynamic. It's constantly in motion. We have marriages. We have children. We have more children that come. We may have divorces of children. We may move homes. We have various life events that happen to require a change in that document. So we want a foundational document that is flexible, that can be easily modified, all right, and can be changed so that it can continue to represent the wishes, the new wishes that you might have as life goes on. So on the screen are the three options. Everyone, again, in this room is going to fall into one of these three categories. You will have either decided at one point to do a trust or a will, or you'll have done nothing. All right? And by the way, you can do nothing, but it is the most, in all likelihood, the most expensive option for our sons and daughters or our heirs in the long run. It might seem like the easy one up front, right? Because I don't need to go sit through a seminar. I don't need to go meet with a lawyer. I don't need to go put any information together. I don't need to update things. But what we want you to know is it's what happens on the back end when we have done nothing on the front end that gets complicated and expensive. And we're going to talk a little bit about that. All right? So the question now becomes, for you, what is the most appropriate direction to go? So let's drill down a little bit on this. The first thing we want to talk about is probate. All right? Everybody's heard that word, right? Everybody knows a little bit about probate. It comes from a Latin word, probatum, which means to prove, or more specifically, to validate a proven truth. Probate is a mandatory state process for settling an estate. And it is necessary unless you have taken the steps in advance while you're still alive, all right, to lay out your wishes so that they may be proven. Each state uses probate, this process of probate, and it has been a part of the fabric of American law for as long as we have been a country, all right? So of the options that we discussed, can you guess which ones are subject to probate? How about if we die with nothing? Do we think we're going to end up in probate? Yes. Great. That one's easy. Absolutely. How about a last will and testament? In all likelihood, you've maybe gone to an attorney, or maybe you've done this yourself. You've had witnesses sign with you, so you've kind of gone about the process. How about a last will and testament? Do we think that if we die that's going to go into probate? Yeah, I see some yeses and some nos, all right? In all likelihood, even if you have a will, your estate is going to end up in probate, all right? We're going to talk a little bit more about that. There is an option to avoid probate if you have a last will and testament. How about a trust? Again, you've put a trust together. Do we think we're going to end up in probate if we have a trust? We hear yes, all right? I saw most of us saying no, all right? Is that just because you figure one of them's got to be the opposite, right? That's how I got through college, right? But that is correct. A trust, by its very nature, is meaning that you've set up in advance what you want to happen. It is a legal document, and it is designed to avoid probate if set up properly, administered properly, and funded properly, which we're going to talk about, all right? But as long as those things are done, a trust will avoid probate, all right? Now, back to the will for a second, all right? When we have a will in Illinois, in the state of Illinois, it is possible to avoid probate, all right? One of the ways is if our dollar value of our estate is below a certain number, we will avoid probate in the state of Illinois, all right? Our heirs will simply process what's called a small estate affidavit, all right? And if the estate is small enough, they'll be able to avoid probate and just take over the assets that you have. Each state designates what their dollar amount is. Does anybody know in the state of Illinois what that threshold is for avoiding probate? I know Jared does. Anybody? $500,000, that's a great guess. It's $100,000. Okay? So in the state of Illinois, if you have personal assets that are under $100,000, you can skip the process of probate, or your heirs will skip the process of probate. All right? Again, they'll simply fill out some paperwork, take possession of those assets, and avoid probate. As you can see from the screen, each state has their own. California's a little bit higher. Of course, everything's a little out of whack in California, right? Arizona, where I live, it's $75,000 is the amount of the threshold. And as you can see, in the state of Georgia, they take their probate very seriously in Georgia. If you die with $1 in your pocket, your estate is going to end up in probate in Georgia. All right? There is another number that I want you to be familiar with. There are 8 states that also have some real estate piece attached to them in regards to probate. Illinois is not one of those. Although if you own real estate in Illinois, in all likelihood, you're going to end up in probate unless you have a trust or you've done some other things to set that up. In California and in Arizona, as you can see, there is an additional column that you get. It's funny because California, $50,000 of additional real estate. What is that, like a doghouse in the backyard? I don't know what you can get for $50,000 in real estate in California. But again, in Illinois, the number that you want to be familiar with today is $100,000. All right? If you add up all of your assets and you are over $100,000 right now, in all likelihood, your estate would end up in probate, or your heirs will end up in the future in probate. All right? In case you're wondering, you can go on to the Illinois Probate Code. If you ever can't fall asleep one night, read some of those statutes. I've highlighted where that number says in the petition, $100,000. And those numbers can change, all right? The state might fluctuate those numbers, all right? So, that's a little about probate. Why should we avoid probate? All right, so let's talk a little bit about why we think it's a good idea to avoid the process of probate. The first is it is expensive, or it can be expensive. All right? So if you look at this chart for just a second, I want to just point out on the left-hand side, just kind of do some math. If I were to add up the value of our estate, including any land or holdings that you have, homes, property, etc., add up your investments, 401ks, 403bs, savings, checking accounts, different things like that, you'll come to a number. Maybe it's $50,000, maybe it's $1 million, maybe it's $200,000, whatever that number is, you can have some idea. The middle value is the estimated cost of probate. Now, this isn't just in the state of Illinois, this is across the country. After doing this for over 35 years, we have a pretty good idea of what the summation of probate is. Okay, probate is the probate costs, the courts have fees, there's attorney costs, there's appraisers, there's all kinds of other professionals that might need to get involved, there's accountants. Each state bills it differently. Some do it on an hourly fee, some do it as a percentage of the estate value. But to keep it simple, it's typically somewhere between 4 and 5% on the low end and 9 and 10%. So 6 to 8% is typical probate costs when you add everything up, okay? And then the last number is the fees. So if your estate value is $200,000, for argument's sake, and you look at probate, there's going to be about $16,000 on average of dollars that would go into that. And it increases as our estate value goes up. Now, no matter how comfortable you are financially sitting here today, I think most of you would say, wow, that's pretty significant dollars that are going to be going out, especially if we know it's not something that we have to pay. All right? It is optional. We do not have to participate in the process of probate if we don't want to. And that's one of the reasons we, as a ministry, think that estate planning is so important. It isn't only that we feel that probate is a waste of money, which it is. We just don't feel paying money that we don't have to is necessarily good stewardship, to piggyback again on what Jared pointed out this morning. All right? So why else should we avoid probate? Well, it takes time. So what does that mean? Typical probate case is going to take anywhere from 9 months to 2 years. Now, if it's some of the examples I gave earlier with gazillions of dollars in the estate, it's going to take decades, okay, or years and years. Typical probate case is going to take around 18 months. It can go longer if there are challenges. One of the long-lost relatives comes up and says, hey, he or she meant to put me into this. They didn't do it. Now that's going to lengthen the time. All right? Additionally, I haven't checked here in Illinois, but where I live, outside of Phoenix, in Maricopa County, where there's about 4.5 million people, all right? 4.5 million people in the county that I live. Guess how many probate judges there are? 2, all right? Now, there are other folks who are helping to sort out the details, but there are only 2 probate judges for 4.5 million people. And we know that 60 to 70% of them are dying with nothing going into probate. So that's one of the other reasons that it takes a good amount of time. All right? The other reason to avoid probate is your assets are frozen. So what does that mean? It means that during the probate process, the money that you had in your accounts, checking, savings, investments, etc., the court will not allow those assets to be paid out. All right? They're trying to figure out what debts, what creditors did you have, who did you owe money to, and so they don't want funds going out until they have all of that sorted out. Now, why might this be an issue? Give you a couple of examples. First is, maybe you own an investment home that somebody's renting. And if the heater goes out in that, and you're no longer around, who's going to pay for that? All right? It probably means that one of your heirs is going to have to pay for the heater to be put in because it can't come out of your estate. Secondly, maybe you were helping to pay for the education of a grandchild, or you're helping to care for a special needs child who's in your family or just was a member of the church, whatever it was. Well, those folks now are not going to be able to receive any of those resources until probate is cared for. Now, a petition could be made to the court so that those funds could be given, but the court does not have to grant that, all right? And it still might take time before those resources are released. So having the assets frozen is a big deal in our eyes. Another reason to avoid probate is the privacy issue. All right? Now, we all know with online and the web and the dark web and all that stuff that our information is out there. All right? I'm pretty sure that Amazon and Google know a lot more about me than my wife even does. At least it feels that way, right? When I go onto that site, how did it know that I wanted that? All right? And can I go on that yearly purge and fast of clothing when it looks so darn nice? Boy, I'd look good in that, right? So why is privacy an issue? Well, let me tell you. Because probate, during the process of probate, those 18 months or so, as they're accumulating all those things about us, who we owed money to, what assets we had, what resources that we have, who we want to give money to, who's disputing this. They're compiling this schematic, if you will, of all of our assets, our resources, our lineage, who we're going to give money to, etc. All that stuff's written down and recorded. And when the probate process is finally finished and it's distributed, the probate court releases the funds and it is distributed, then what they do is they box up all that information and they take it, and in the county clerk's office, all of your records are kept housed in boxes, literally. Some of it's going online now. Now, why might that be an issue? The issue is you could go down to the county courthouse tomorrow morning, Monday morning, and say, I want to see the probate records for Mr. Johnson or Mrs. Anderson or whoever it was that has passed. And if they ended up in probate, you would get to see all of that information. What they had, who they owed money to, and the part that's more disturbing to us is who they gave money to, right? Because we know that if somebody has received a significant inheritance, that they certainly would be somebody that somebody might have interest in. We just don't think that's a good idea. So your information all becomes private. Our best wishes is that it stays all within our immediate family, and we're going to talk a little bit about the way to do that, all right? But understand that if you end up in probate, that your records become public information for anyone to see, all right? So what we want you to understand is you do have a choice in regards to probate. If you have a will or if you have nothing, you're going to, in all likelihood, end up in probate. If you have a living trust, a revocable living trust, set up properly and funded properly, which we'll talk about, there is not going to be probate. None of those things that I just talked about are going to be part of your estate. All right? So let's dive a little bit deeper. As you can see, we're starting to say, we think a trust is a good idea. Now, many of you maybe have not even considered doing a trust because you're like, we don't have that much stuff. Or it's just too expensive. I don't want to set up a trust. Or a trust is just for rich folks, right? Well, we know that we all have things, and we understand that this might be a good thing. What we want to point out is trusts are now an option for you, all right? Because forget the expense of setting it up and the hassles. We're going to assist you and walk you into that. So let's talk a little bit about a living trust. A revocable living trust, some of the advantages and elements of that trust is it avoids probate, which is one of the main things that we talk about. It's also less expensive because it avoids probate, and because the option or the reality is it's much more difficult to contest a trust than it is a will, or to win when you have contested a trust. And what drives up the cost of probate and our estate is when lawyers have to get involved to handle squabbles and when things are contested. All right? A trust also eliminates the lengthy delays of getting things done. Again, 9 months to 2 years typically, around 18 months when we end up in probate. But if we have a trust, we're going to get into some of the details here, okay? But when we have a trust, normally, if we're older especially, the trust process can be completed in 90 to 120 days. 3 to 4 months. A trust from time of death until the trust is closed is typically 3 to 4 months. Because the entire process is controlled by someone that you put in place. It's called a successor trustee, and we'll get into that, all right? They are the ones that are administering this. It's not going to a court and letting them take care of it. It's somebody that you've put in place that's going to take care of it, all right? Also, having a trust, we preserve privacy. So when we avoid probate, we don't end up in the public domain, all right? When you use a living trust and you avoid probate, all of that information, all of your heirs, the beneficiaries, what they received, who you owed money to, all of your assets, none of that is made public because you've stayed out of the court system. Unlike a will, you don't file a trust anywhere. It is private while you're alive. It is private between you, your trustee. In a will, we call that an executor. In a trust, we call it our successor trustee, and those beneficiaries or the heirs that you've set up. All right? In essence, it stays in the family. All right? It's also completely flexible. So a trust, because it's a revocable item, it can be changed, modified, amended, revoked, canceled at any time. It also avoids the problem of joint ownership or joint tenancy. So let's camp on this one for just a second. Many of you here, I'm seeing, are married, all right? And you're probably familiar with this term on your deed called joint ownership with rights of survivorship. That means that you and your spouse own the home together. And joint tenancy means that when one of the spouses passes away, the other one automatically now owns that home. All right? Does not need to go to court. Lawyer doesn't have to get involved. There's nothing that has to happen. It's simply the surviving spouse now owns that home, right? Well, not only does that work for spouses, but it can also work for anyone that is over 18 years of age. So I want to talk about this for just a second. You can have multiple people as joint tenants on your property and on your real estate. All right? So if your goal was to pass on that asset and avoid probate, one of the ways that you could do that would be to add them onto the deed. All right? You could simply name your child or your children as joint tenants on that property. Then when you, and if you're married, your spouse pass, it automatically belongs to them. no probate, no attorneys, no costs. It's automatic. Sounds like it might be an okay deal, right? Well, let me tell you why. Here's the problem. If you put your son or daughter on that deed, or let's even expand it, because some of you have probably done this, or you add that son or daughter to a bank account just so they can write checks. Put them on as an owner of that account. If, heaven forbid, that child or children, one of them were to get into a car accident that they caused, had a bankruptcy, had a divorce, or had anything that negatively impacted them, if their name is attached to your asset, then that asset is subject to creditor's claims. All right? This is a very serious matter, and I can guarantee, even with a small group like this, that there are folks who have done this, or you are on mom and dad's deed. All right? This is a serious matter, because here's what we want you to know. You could go down to the title company tomorrow, and without your son or daughter even known, you could add them onto your deed. All right? Then when you and your wife pass, they would own the home, avoiding probate. Or you could add them onto your bank account. And when you and your spouse passed, they would own the bank account because they are now an owner on that particular account. And when you did that, the title company person or the representative at the bank would assist you with doing that. Now, they're not doing it because they know that it could cause harm. They're just doing it because you've requested it. And they probably don't know the ramifications and the consequences that can happen. But I can tell you, as we're associated back and forth with the legal community, that they deal with this all the time. All right? And there are tragic results that can come from this. So if the reason that you wanted to add that child's name onto the deed or onto the bank account was to avoid probate, there is a much safer way to do that. One way would be to create a living trust. All right? And then you hold that property in the name of the trust. And we're going to talk about how to do that, okay? Now your home is in that trust. And all you do is add that son or daughter or multiple people as beneficiaries to that home in that trust. Then when you and your spouse pass, that home simply goes to that child or those children, avoiding probate. But those kids are not on that deed, or they're not on that bank account or on that investment account. And so, again, if something bad were to happen, if they were to have an accident or they were to get sued or they had a bankruptcy, they are just heirs or beneficiaries of that asset. They are not actually owners of that asset. And yet, at your passing, the same thing happens. All right? You and your spouse pass. There is a living trust transfer of that property. And this is a much safer way to handle things, all right? As a ministry, we've met with thousands and thousands of people over the last 35 years. This is one of those common missteps that is innocently set up but can potentially have some really bad results, all right? Now, I'm not going to ask for a show of hands because I can guarantee you that some of you have either done this, you're thinking about doing it, or you are actually on mom and dad's deed or someone else's deed. All right, I can guarantee you in a group this size that has happened. What I want you to understand is if you have added a child, son or daughter or someone to your deed or to your bank account, that it is not too late, all right? You can reverse that process. However, you didn't need their permission to put them on the deed, but you do need their signature and their approval to get them off the deed, all right? So we suggest perhaps you invite them over for their favorite steak and lobster meal, right? And maybe the conversation goes like this. Well, son, you might be wondering why the notary is here with us, all right? Simply sign here, press hard, and we'll move on to dessert, all right? We want you to understand that it's not too late. You can get them off that deed or off that bank account, and we would strongly suggest that you do that because a trust is a much safer way to pass on and avoid probate, all right, pass on real estate. Another advantage of a trust, it avoids court-imposed guardianship for minors. All right? So many of you, it looks like we've got some young folks here, which is great to see as well. Some of you are raising kids who are still minors. All right? And as you brought up earlier, it's not always easy what's going to happen, right, with those kids. But what we want you to understand is if for some reason you and your spouse were not here, if there was a common accident and both of you perished, who is going to raise those kids? All right? And what we want you to understand is if you have just said, hey, sis, or hey, brother, or hey, friend, if something were to happen to me and Tony, would you take care of the kids? Well, that's a great start, but legally that has no authority over what's going to happen with those kids, all right? You have to put that into a document if you have kids that are under 18 years of age, all right? Now, figuring out who you want to take over guardianship, as you pointed out, is not always easy, all right? This is always one of the fun parts that we deal with. When I sit down with younger couples, it's very interesting, and I won't name which spouse it typically is, but usually she'll say, well, for sure your family ain't watching the kids, right, or taking care of the kids, all right? It's not always easy. Some of you, it's real obvious, but for others, it can be a challenge. Who is it? But here's the deal. We still think it's more important to struggle over that, to battle about it a little bit, but then to figure out what is the best option today to watch those kids if we weren't here. Again, in all likelihood, you're going to raise them till they're old. But if for some reason you weren't here, who would it be? Because if you don't put it down in a document, the court is going to decide. And they may not make the decision that you want made. So even if it isn't the best or the ideal decision, you wish that just there was somebody that had the same beliefs, same, love of the Lord that you have, put someone in place that is the best option for those kids. All right? Because it's just one of those things that we know is important. All right? And you can do this in either a trust or a will, but get that information down. And as an aside, I see we've got some folks that are a little older here. You've graduated perhaps from raising those youngsters, and now they are off on their own. Hopefully they're off the payroll, right? Mine are getting there. I have a 20 and a 23-year-old. All right? My daughter is just finishing up school. My son just finished. So we're done with the guardianship part. But if you've graduated from that and your kids are now starting to have their own children or thinking about it, so you've got grandkids or grandkids are going to be coming, this is some conversation to have with them as well. Who, if your children were not there, them and their spouse, and they have kids, who's going to raise those kids? All right, so have that dialogue with your own children because you might be surprised. Maybe they want you to raise those kids if they're not here. And that might be a blessing. Or it might be, wait a minute, you were enough trouble. We don't want to be raising your kids, all right? But they should put that in a document so that those grandkids are protected as well, all right? Again, we don't like the idea of the state or the court system making any decisions for us when we know that it can simply be done in advance, all right? So, in addition to protecting our children and our grandchildren, we want to also protect our own interests, and we do that through something called a conservator or an adult guardian, depending on the state that we live in, all right? There may come a time where you are mentally unable to make your own decisions, either from dementia or a stroke or some other reason. Maybe you were in an accident or something like that, all right? The trust document allows us to name a guardian, an adult guardian or a conservator to care for you, okay? So that when or if you got to that point of being unable to make those decisions, that this was already set up. You have someone named that is there to make those decisions and to protect and care for you and make those decisions on your behalf, all right? Another element of the trust is it is quick distribution of assets. So just as I talked about where the probate's going to take a couple of years potentially, the trust document can be settled in as little as 90 to 120 days. Also, another element of a living trust, it can be used to reduce or eliminate federal estate tax. All right? We can use something called an AB trust to reduce our federal estate tax. Now, I'm going to circle back to this AB trust, so just set that aside for just a second, all right? So far, we've been talking about probate and things on a state level and what happens in regards to costs at a state level. Now, for some estates, the federal government also is interested in us when we die, all right? It's typically for larger estates, all right? It's nice to know that Uncle Sam cares about us so much, right? The government has a number in mind as well. And if our estate level, meaning the amount of resources, the amount of money that we have in our estate, is above a certain level, then the federal government wants to tax that. And again, here at Financial Planning Ministries, we think paying our normal tax is a great idea, but we don't think that when we die, it's a great idea to give any more money to the government than we need to, all right? So it is possible to also either avoid or minimize or eliminate federal estate tax. Does anyone know what the dollar figure is that triggers the federal estate tax? It's big. 11 just went up 5 days ago to $11.58 million. So if you're below that number, you have nothing to worry about, all right? I saw a few sighs of relief, all right? Now, as you can see, this number through the years, it's ever changing, all right? It really depends on who's in charge, what party is creating these laws. But as the years have gone by, it's actually been a pretty good deal that the government has given to us, right? If you add up your entire estate, this is the amount that you can pass on to your heirs before there's any federal estate tax, all right? But if you are above that amount, it's a pretty significant chunk that the government's going to take. It is 40% of the assets end up going out in taxes. Now, the truth is, obviously, way less than 1% of the population has any issue with this federal estate tax problem today, all right, right now. But what we want you to know is that this does exist, all right? Because just because you are below that number today, perhaps through an inheritance or a successful business venture, or the government could just change their mind as well and modify this number. If you look for a second at 2010, you can see, and I know this is hard to believe, but the government couldn't come to a consensus, all right? I know that we just can't fathom that. In 2010, they just couldn't come to an agreement, and so they repealed the law. So what that meant was in 2010, you could die with any amount of money, and none of it went to the government. We missed out on a great deal, right? I mean, 2010 would have been a heck of a time to die. You could have been a billionaire and passed in 2010, and your estate paid no tax. And in fact, there was a few billionaires. One of them you're probably familiar with. His name was mentioned a number of times on Seinfeld. Also used to own the Yankees. He was a shipping magnate. Anybody remember George Steinbrenner, right? Steinbrenner passed in 2010. It's estimated somewhere between $4 and $6.5 billion of net worth, and paid zero tax in 2010. Now, I'm sure that Mr. Steinbrenner's heirs miss him. However, they were probably fairly pleased with his timing, right? Because if he'd have passed any other year other than 2010, 40% of that estate, 40% of $6.5 billion would have ended up going out of it to the federal government, all right? So, since this affects so few of us, why do we spend any time even talking about it? The reason is that the federal estate tax is a political football, okay? And depending on who's making those decisions in Washington. And in fact, this is something, again, that just changed when, remember in 2017, they changed some of the tax laws. Well, this was one of the things that went up, went from $5.5 million to now over $11 million, okay? And we understand that at $11 million, most of us just zone out. We don't even think about it, right? However, we understand that amount could be reduced. If you haven't been following, the federal government is in some debt, all right? Trillions of dollars of debt. And there might become a day of reckoning when the government just says, we got to tax anything that we can, and the estate is something that we should tax. And so we should move it from $11.5 million to, pick a number, $1 million, or 500,000, or 100,000, or whatever that number is. And now, that might start affecting most of us, especially because estate tax also includes any value of life insurance that you have. So probate does not include life insurance. But just because you have that life insurance when you die, that is added into that estate value. So if the probate or if the federal estate tax threshold was, let's say, $500,000 when you and your spouse passed, and you have $1 million life insurance policy, half of that right there would be taxed at whatever that tax rate is. Today it's 40%. So it can be a significant deal. So we just want you to be aware of it. Because if that number does change, there are some things that you can do. One of the things that we can do, and I'm going to circle back now to where I started, which is called this AB trust. All right? What is an AB trust? Well, one of the things that can assist in reducing or eliminating this federal estate tax is to be married. Just another benefit of marriage, right? Now, why would being married ease our federal estate tax burden? Let me tell you real briefly. A married couple can do what's called an AB marital trust. So what that means is, instead of having $11.58 million, you get to double it. Because it's really one trust that has two trusts, an A and a B trust, and I'm not going to get into particulars, but just envision it's you and your wife each having it, or you and your spouse each having a trust, and you get to double the exemption. So you go from $11 million to over $23 million. Okay? Now, that might not matter when it's 11, but if it was 500,000 in the example I gave, it might make sense to do an AB trust, because now you could get up to $1 million instead of just 500,000 exempt from the federal estate tax. Okay? So again, it is just another advantage of being married. Now, some people ask, hey, I'm single. What about me? I get a lot of people that come up afterwards and say, hey, I'm not married, not planning on getting married, or I don't think I'm going to get married. Is there anything that I can do if I'm single to get this exemption? Okay? And usually what I say to them is, if you're single and you're worried because you are thinking you're going to fall into that federal estate tax currently, a couple of words for you. eHarmony, Christian Mingle, okay? One of those dating services. I'm guessing there'd be somebody that would raise their hand and say, hey, I'll be your exemption, right? In all seriousness, what we want you to understand is that if those taxation levels change, and we want you to be aware that they exist, but that there are options, and through some basic planning, documents can be put in place to avoid them, all right? So those are some of the advantages of a trust. So let me spend a few minutes, because this trust idea is still kind of this nebulous, unknown idea for many of us, right? So how does a trust work? How do we create it? What is it even, all right? So let's spend a few minutes talking about that to try and clear things up. When we create a trust, it's just a document that is put together for you, and if you're married, for you and your spouse. We name ourselves as the trustee, meaning we are the ones in charge. If you're married, it's you and your spouse who are the trustees. You're the grantors or the creators of that trust, and both of you are now trustees of that trust. When one of you passes, the other one becomes the trustee of the trust, and when both of you have passed, we name a successor trustee. The successor trustee is the individual, bless you, individual that you have named that is going to come in and act as you when you're no longer here. They're the ones that are going to administer or take care of all of your wishes that you have put into the trust. So the successor trustee is the most important position in the entirety of the trust. All right? Now, just as guardianship, finding out who is going to be your successor trustee, for many of us might be real easy. But for some of us, it might be a challenge. All right? Who do I want to put in place to carry out the decisions that you or you and your spouse have laid out? Now, many times the default is just our children. All right? First of all, they have to be over 18. They should be responsible. They should have a go-get-'em personality and desire to get things wrapped up. All right? And it needs to be somebody that you can for sure trust carrying out your wishes. All right? So the successor trustee is somebody this is the vital position. Now, what we strongly suggest is that you name who that's going to be, and then you name an alternate as well, just in case they were to predecease with you or to pass before you, what have you, okay? If you can't come up with an alternate, you have to have one. You have to have somebody that you've named besides you and your spouse that is going to carry out your wishes. So successor trustee is the most important part of the trust after you guys. Then we name a conservator. So this is that guardian or conservator that is going to assist with making medical decisions. The liaison between you and your decisions and the medical staff. What is it that you have decided? Now, most times, the first person will be, if we're married, that'll be our spouse. Doesn't have to be, but typically that's what it is. But you'll also want to name who's going to be a backup. My wife and I are each other's guardian, but if we were both in a car accident, we've named our son, who wants to be a doctor, he's 23 now, Zach, as our alternate. And then we've named our daughter, Abby, who's going to be 21, as a backup to Zach. So you need to name those people. It does not need to be the same for each of you. Okay, and occasionally we have blended families. Some of you might have a blended family. You might not want your spouse's child to be making the decisions for you, so that's why there's an option for you to have whoever your children are, or a friend, or whoever that is. All right? And again, those will be some documents that would be provided to you. Then we want to name, if we have kids that are under 18, we want to name guardians for those children. Who is it that's going to take care of the kids if we were to pass? And you can have alternates on this as well. All right? And we'll walk through some of these questions if you can't come up with those answers when we get together, if you want to meet. Then step 5 is to name the people and the organizations, charities, churches, etc., that you might want to receive some of your estate. So who are going to be the heirs? Who's going to get those resources? What does your last stewardship act look like? Okay? Whether you die with $10 million, $10,000, or $10, there are resources that should get passed on to kids, friends, nieces, nephews, other relatives, and those organizations that you love, including your church and other potential nonprofits that you might have an affinity to. Okay? Then, this is the part that a lot of people just don't quite get this. All right? So I want to spend a couple minutes on it. Then what we do when we create a trust, we retitle our assets into the name of the trust. So what does that mean? The reason we're able to avoid probate is because we take things out of our name and we put them into the name of the trust that we've created. That's what makes it different than a will. If you have a will right now, your home is still in your name and your spouse's name. Your bank accounts are in your name. When we do a trust, we retitle those into the entity that was created, this new living trust. And because they're not in our name anymore, we don't own them as the government would look at that. We're able to pass those assets on in the manner that we want and avoid the process of probate. So this is called funding the trust, not to get too particular, but all it means, I'll use myself as an example. My wife Jody and I used to own our home. It was called J. Fellows and Jody Fellows as the owners on that deed. When we set up a trust, our last name is Fellows. It's now the Fellows Family Trust, Jay and Jody as trustees that now own that home. So I still own it because I'm the trustee of the trust that has ownership of that home. I can sell the home. I can remodel the home. I can do whatever I want in the home. I can rent the home out if I want to. Nothing changes except I don't physically own it. My name is not on it, and my wife's not on it. It is our trust name that is on it. And we do that with all of these assets. So whether it's just your home, maybe you have a cabin up in beautiful Wisconsin or Minnesota, or you own some investment property, or whatever that is. We also do that with savings and investment accounts. We don't do it with IRAs and 401ks. We'll talk about that in just a second. Any other titleable asset, we can do it with our vehicles, okay? If we own a mobile home, anything that you have your name attached to, RVs, trailers, ATVs, anything like that, can all be named into the trust. And by doing that, you've taken ownership from you, moved it into your trust, and those will pass freely to whoever you've designated, avoiding probate. Okay? So there are some steps that have to happen, but we assist you along the way in doing that and showing you how to do that. Or you can do it yourself, but we will assist you in that. All right? We'll talk more about that if we get together on a one-on-one. So, we're nearing the finish line. Let's talk about a few questions that might be resonating in your head right now. All right? Is the living trust a new idea? No. It's been around, it's way older than this country. All right? We got it from the Brits, who got it from the Romans, who got it from, I'm not sure who they got it from, but it's been around, trusts have been around a long time. All right? Does the transfer of of property into the trust affect property tax? So that transfer that I just said, does that affect anything? No. You still pay the same property taxes. There's no sale that happens when you transfer that property. It's called a no-sale transfer, okay? So there is a deed fee, usually about $15, might be $20, depending on the county that you live in, taking it from you into your home, but there's no other transfer fees, property tax fees, anything like that. May I include the distribution of personal items in my trust? Yes. So those other things that are not titleable, wedding rings, collections of coins, stamps, guns, whatever that is that you have, all right, that you want to pass on. Maybe you have some musical instruments, some artwork, whatever that is. A grandfather clock that came from great-great-grandmother, all right? Any of those things that you want to pass on, it's called a Schedule C. You will list those items and who it is that you want them to go to, and the transfer will take place, avoiding probate in the trust document. Is it necessary for financial planning ministries, that's us, FPM, to know the total value of my estate? So in that workbook, this planning guide, we ask for some ideas on savings accounts, 401ks, checkings, different things like that. Okay, we want to have some general idea so that we can help minister to you on some ways that you can do some things. We want to know also if you're bumping up against any thresholds, all right? So that we might need to do an AB trust or something like that, and to have an idea in the future. We do not want account numbers of anything. All we want to know is, okay, we bank at Chase or the local bank, and we have approximately $5,000 in it. Okay, here's our home. Here's the address. It's worth $200,000 or $500,000 or whatever that number is. Give us an idea of what those assets are so that we can help guide you along in the process. Understand that Jared's company, CFR, and your church here does not get access to any of that asset level that you have. They don't know anything about the accounts that you have. That's a personal agreement that we have as FPM to you. Okay, that all stays confidential, all right, as far as asset levels and different things like that, all right? Number 5, may I make changes in my living trust after it's notarized? Yes. So this is one of the beauties and one of the things that I want to be clear on. When you set something up in your trust, it can always be modified with a revocable living trust, all right? And if you do something with us, this is one of the beauties, we will continue to make any changes, modifications for as long as you are on this side of heaven, all right? So any changes, any amendments, any modifications that you need to do, we'll do those for you, all right? And there's no costs for those, all right? So those will... Many people will update their documents 2, 3, 4, 5, 10, 20 times, especially if they start out when they're younger. Okay, so you can make changes at any time. You can also cancel it if for some reason you want to. Does a living trust make sense for a single person? Well, we think so. I mean, especially if you have children, especially if you have any amount of assets. Even if you're single, we think it makes sense. Same if many of you are probably sitting here thinking, boy, I've got a small estate. I just don't have much. Understood. Most of us would think the same thing, and many of us, if we're younger, start off that way, but it might grow in the future, and so it's great to have a foundational document that will handle things as you go through life. One of the other reasons, whether you're single, think you have a small estate, or whatever your situation, is this. I'll give you an example. One of the great things about a trust is we can govern or modify or pause the amount and the time frame that our heirs would receive their inheritance. Okay, so let me put a little meat on that for you. Okay, I'll give myself as an example. Again, my wife Jody and I'm a business owner. I do financial planning business or financial planning ministries, and I have a business, and I've been a business guy for the last 30 years. All right, we have some assets. I have a business. We have a home. We each have 401ks or 403bs. We have checking savings like many and most of you. But we also have some significant life insurance. My kids are still at that age. We've got 6 years left of life insurance. Many of you probably have life insurance as well. So our asset level is probably like many of you. But when you include the life insurance on it, it's a pretty significant dollar amount. All right? I had a friend that was in the life insurance business, and he signed me up for a lot because, it's only $27 a month. Let's sign it up. And so we got a lot of life insurance. But here's what my wife and I have done. We have said, if we die, our kids don't get our money right away. They get it eventually after we've given to charities and our church, etc. But here's what we've done. We've said, life insurance, if my wife and I were to both pass in an accident tomorrow, all right? Our life insurance, our 401ks, our investments, all are in the trust or would funnel into the trust. We've said, don't pay our kids, pay the trust. And then we've told the trust to pay for their education, continue to give them money as they go through school, university, med school, whatever that is, but wait to give them money till they're 25. And then at 25, they can get half. And at 30, we've said they can have the rest of it and then close the trust. Because although my kids are great kids in my eyes, I remember me at 20, okay? Me at 20 getting a significant amount of money would not have been a good thing for me. And so we just know that giving a large chunk of money, again, not because we're super wealthy, but mainly because of our life insurance, would be a good idea. And so we instead have set the trust up to govern some of that. And you might have similar situations with your kids, all right? So that even if we're single or even if we have a small estate, if we have life insurance or we want to govern the amount and the time frame, we think a trust is a great idea. Does a living trust avoid probate on out-of-state property? So let's say you own a property, your main property here in Illinois, And then you've got a property up in beautiful Door County, Wisconsin, which if you've never been there, you got to get there. It's amazing, all right? And then you've got, let's say, another investment home down in Florida, all right? You've got 3 properties. Well, here's the reality. If you were to pass, you'd have 3 states that wanted to probate your estate, all right? Now, to be fair, most people that own multiple properties understand the advantages of having a trust. And so many of them already have those homes already in the trust. But just to carry out the example, all you'd simply do, if you had those 3 properties, is change the deed from you owning them to your trust owning them. So one trust document that you and your spouse have, if you're married, each of those deeds in 3 different estates is now owned by that trust. You avoid probate in all 3 of those states and simply pass those assets on, avoiding probate, however you want that to happen. All right? Now, it works in all states with us. It works in all states except one. There's one state that we cannot assist you with. Anybody have an idea on what that state might be? Illinois? Well, that would be a struggle if that was the case. It is not Illinois. We can assist you in Illinois. Hawaii's a good guess. Most people think California or New York. I'll give you a hint. It is one of the states that does not have counties. It has parishes. Louisiana, exactly. So in Louisiana, we love their cooking. We love their revelry, right? We love their music. But they still do things in the French law, and we don't. And so if you own property in Louisiana, we just tell you to sell it. No, I'm kidding. If you own property in Louisiana, you can still do something, just you'd have to take that property. We would guide you to an organization called the Christian Legal Society, and they would assist you with that. But any other state, we can help you with the property that you own. All right? Does the living trust restrict my rights to my property? No, there's no restrictions. You're the trustee. You're the grantor of the trust. You made the trust. You can do whatever you like with that property. Again, sell it, remodel it, rent it, do anything you'd like. All right, we're at the finish line. So if we'd like to establish an estate plan, if any of this sounded like, hey, I'd like to take it to the next step, how do we do that? Well, let me walk you through the options that you can do. You can do this yourself. All right, you could simply go online. There are some sites online that you can do this yourself. Sometimes they'll be free, sometimes they're $75, $100. But you can actually set up your own trust. Just as you can represent yourself in court, you don't need a lawyer to set up your trust. You can do this on your own. All right, and some people do that. And that is fine if you want to do that. The second option is to use a local professional. And there are many good ones. Okay? Understand that setting up a trust will include a trust, what's called a pour-over will, advanced medical directives, powers of attorneys, et cetera, et cetera. Typically, depending on your estate, number of properties that you own, et cetera, you're looking at probably $1,000, $1,500 to $2,000, $3,000, $4,000 and above. All right? And then any changes that you make, normally there's going to be some additional costs on that, so $200, $300, $400, $500 each time you make those change. Now, if you decide to go that way, and again, this for some of you, this might be the way to go. Find an attorney or an organization that just does estate planning. All right? Only about 10% of the professionals just do estate planning. That would be our suggestion. All right? But no matter what you do with those first 2, if you do either of those options, consider being generous with the resources that God has given you, okay? Our whole goal here is not to bring on clients. That's not it. Our whole goal is generosity and stewardship, to piggyback on what Jared said this morning. Your third option would be to do something with our organization, all right? Now, we have done this, as I said, for the last 35 years. We have helped out, right now it's about 31,000 families that have put together estate plans with us. And again, we're only able to do these documents, the preparation, what you're seeing here today, the meetings that we put together, because of organizations like CFR and the 100 and One partners that we have, all right? They finance this for us so that you are able to get this put together at no upfront cost, all right? Yeah, woo! Thank you, Jared. The other thing I want to point out is some of you might have wills. Some of you might even have, do we have any people that have trusts currently? All right, see a couple of hands. If you have a trust, that's great. If you have anything that you want looked at, or if you want anything modified or amended in that document, we'll assist with that. So we will also take your existing trust, and if there are changes that need to be made, we will amend that for you as part of the service as well, okay? In addition, if there's anyone here, and this is really a soft spot for me, but 5 years ago, we started also doing special needs trusts. So if any of you have a special needs child or are familiar with anyone that has a special needs child, you know, or you may know, or maybe you don't know, there are some special provisions that need to be put in place so that none of the aid or the resources that they might be getting, the SSI, et cetera, doesn't go away, all right? Because what happens is if a special needs individual receives an inheritance, and I think the number, it's a little different each place, but it's about $2,000. If they receive over $2,000 in inheritance, their support ends. All right? And so we decided to get into also doing special needs trusts. So we will design, and it's a little more complex, and it takes a little more detail and a little more work, but we will do that for you, again, as part of this package. So if any of you have a special needs child or know someone that does, we would love to assist. By the way, if you went to a organization or an agency to get a special needs trust, it would typically cost you between $4,000 and $8,000 to get that put together. Okay, so that becomes part of the service that we will do as well. We do not charge a fee up front for these services, again, because of the partners that we have. The only thing that we ask is this. We do this work so that members of this church, partners within this organization, and those that they care about are able to get paperwork put together. But our real emphasis and our heartbeat is stewardship and generosity, all right? We think this is a great way to get paperwork done, but we know that it's also a great way to be charitable in the future. And so when you no longer need those resources that God has given you, you and your spouse, if you're married, have both passed on, we would ask you to consider leaving something to your church, CFR, to any of the other organizations that do this, and to anybody that we're not familiar with but is enhancing God's kingdom as well. That might be a university that you've gone to. It might be a camp that you went to as a kid, some organization that you want to bless. That's what we're all about, is finding ways to be great stewards of the resources that God gave us. So here are the two things that we ask. First, if you're going to do this, if you're going to get started with this process, we are a nonprofit. We'd ask you to really pray about that and to consider taking it from start to finish. It doesn't mean you have to. We know that things get in the way, but make a commitment to doing it if you're going to. And secondly, if you are going to do it with our organization, we are a charity, we're a nonprofit, then we would ask you to prayerfully consider leaving something when you no longer need those resources to enhance God's kingdom, okay? And that's it. That's all I'll say on that. That'll really be between you, your spouse, and the Lord. How generous and what do you want to do with those resources? And because we're doing it here at your church, we'd ask you to consider leaving something to your church as well. We would love for an organization like this church who's expanding. I understand from Pastor Rusty that there's going to be some new enhancements that are coming on. Well, think about 10, 20, 30, 40 years. If some of those resources came, Rusty, you might still be up here that, might have a gray beard at that time. Or who knows who's leading this church. There might be a blessing that could come at that time. Okay? So, how do we do this? Complete that planning guide. So, Jared told you don't look at this. I'm glad he said that. Now you can look at it. But it is about 16 pages long. It's pretty in-depth. We want to know some things about you, but we also want to know what you want to do with your kids, with your assets. Who do you want to leave things to? What organizations would you like to bless, etc. So fill that out as completely as you can and bring that along to a meeting if you'd want. Usually, I'll be back and I'll show you those dates in about 3 weeks to meet. The whole process is usually completed within 90 days. Usually it's 60 to 75 days by the time we get this booklet completed and sent in. By the time the documents come back to you, those documents need to get notarized. Do we have a notary in the church, Rusty? Okay. Someone probably does, or a local bank or an organization would be able to assist you with getting those notarized and witnessed. And we'll talk about that, and we'll figure out a notary for you by the time I come back. As I mentioned, if you have existing wills, existing trusts, we will certainly assist you with looking at those. We'll also complete any updates that you make from now till you're no longer here, and it also includes special needs trusts. So if any of you are interested in perhaps meeting, when we come back, write this code down. It's the name of the city, Minear, is that right? Minear. MINIER 120, and the appointment dates. I'll be flying back in on Tuesday, so I won't be able to do appointments till late afternoon and evening. I think they start around 4:15 on that Tuesday and go till 7 or 8 o'clock, so I'll have about 4, 5, 6 appointments. All day Wednesday, the 29th, from about 8:30 till 7 or 8 o'clock. And then Thursday will be a backup. Depending on how many people sign up in the first slots, we'll see if we need to open up Thursday, but that might be a possibility as well, and we'd do some in the morning or early afternoon at that time. But fill up the first 2 days at first. If you haven't filled out your name and email, that's how we're going to fill it in. We need to get that information. Again, we are not going to sell you anything. We're going to send you about 2 or 3 emails giving you the dates and giving you an opportunity to sign up for the appointment. You can click on the email that comes. It's the appointment email, and that will take you to this page. You'll click on Illinois, and then enter in that code, MINIER 120, and that will take you to the dates. Simply click on one of the buttons, and it'll ask you for your information. As well, if I go back, that email will also include a digital planning guide. So this book can be filled out on your computer, which is really nice for me as I go through this, all right? Printed off and brought to the meeting, okay? Now just understand that if you have a Mac or you have occasionally some of the systems don't work well, if you're going to save it, if you're not going to complete it in one sitting, make sure that it saves, and it saves the actual information that you put in. Occasionally people save it, they go back to open it up, and it's blank, okay? So just understand that. But you can print that document out, bring it along, and we'll get it processed for you. Okay? If you are one of those type A personalities, all right, and you want that appointment and you want it now, you can actually go to our website, which is fpm.org, fpm.org. Click on that top right button, which says Appointments, and that will take you to this page. You'll click on Illinois, enter in the code, and it will give you the same thing. So you can do that today if you want to get one of those appointments, if some of you are working and, hey, I got to have that night appointment or whatever. Or you can wait for the email. We're going to send you an email probably tomorrow. Tomorrow or Tuesday you'll get an email from us, and then a reminder or two after that. Okay? You can also check us out, follow us on Twitter, Facebook, look us up on LinkedIn, and there's our phone numbers and information. So, what I'd like to do, and I know some of you probably have to run, I'd like to take just a couple of minutes, answer any questions that you might have, and then I'll stick around for a couple of minutes and sidebar if anyone has anything personal they'd like to ask. Anybody have any questions that are just dying to? Go ahead, Jared. Signed up? Awesome. Questions? Yes, sir. Yes. Great question. So I think I skipped that part. 401ks, IRAs. Great question. Those are already beneficiary accounts. So here's one of the ways that things we'll talk about, though. You can name your spouse. Normally, if you're married, you name your spouse as that first beneficiary, right? The question then becomes, who is your alternate or second beneficiary? Many people just default and name their kids. Well, maybe that's a good idea. In our example that I gave you, we don't have our kids named as the alternate. We have our trust as the alternate. That way, if, again, my wife and I were to pass in that car accident, now there's no spouse to pay, those funds from that company will be funneled to our trust so that the trust can do what we've wanted it to do. So yeah, 401ks and IRAs, annuities as well, 529s, different things like that, they need to stay in our name, but they're already beneficiary accounts. But one of the things that you'll want to determine is, do we want to have our kids as a beneficiary on that, or do we want to name the trust? And we'll talk about that in the meeting. Good question. Yes, ma'am. So, is there a way to schedule money to whoever we've named as the guardian of the child? You want to make sure that they're not coming up with their resources to take care of your children. Is that right? So, you can dictate that how you want. It's your trust. However, what we'll tell you is the trust document already does that in advance. All right? We understand that if we have young kids, that they're going to need to be cared for by the guardian. The intent that you had when you asked your sister, brother, or friend, or whoever to take care of your kids if you're not around was not so that they would be pulling all their retirement money out to raise your kid. All right? So any of the money that you have left for that child or those children would go into basically a children's trust silo. From those resources, A, would be invested, hopefully with Jared's company. All right? But B, those resources would be used to help raise those children till they got to be 18. So paying for shoes, backpacks, care for them on a monthly basis, and then education for as long as they went to school, and then it would be paid out to them whatever's left in those resources. So I'm sorry, go ahead. Would go to the child at that point, exactly. Yep. You can make special designations to guardians, but the trust does a great job of explaining how that is going to happen. Okay? Yes, in the back. Yeah, great question. So let's say you put a trust together and you end up in a nursing home. Okay? So you've done some things in advance, gotten those taken care of, funded the trust. You go in that nursing home, your wishes are now intact. Now, can you modify that trust while you're in the nursing home? Yeah, as long as cognitively you are still around. You can still make changes or modifications. But if you end up in that nursing home and then the Lord takes you, your wishes are now in place. And that's one of the beautiful things. Oh, so what you're talking about is, okay, what about the assets that I have? Are those going to be able to be gone after to help pay for nursing care, et cetera? It's a great question. So that is not the design of a revocable living trust. All right? This is not going to, even though we're separating ourselves from our assets, you still own them in the eyes of the government in regards to nursing care. So moving your assets into the trust does not show you now having zero assets and you get to keep all this and go into the nursing home and the government pays for it. All right? It does not do that. If you want some assistance on that, I'd strongly suggest meeting with an elder care attorney or someone like that. They can help do some things. That's not what we do. The revocable living trust is basically designed to help avoid probate and to transfer assets simply, but it's not to avoid or get rid of assets so that we can have nursing care paid for. Okay? But I saw, yes, sir. I'm not sure I understand. So decisions you make now in regards to how you want to pass things on, can those be changed once you're gone? I'm not sure I still understand. So can you give me a little bit of an example? Okay. You can. So our suggestion is keep it simple. All right? I'll give you an example maybe of what you're talking about. Some people, especially not ours, but many people that have some significant assets, they want to, we call manage from the grave. Okay? So they don't want, unlike where I give you the example of when our kids turn 30, we want the trust closed. The idea with the trust is to avoid probate and get those assets paid out and then close the trust. But if we have young children, trust is going to need to stay open. But we don't want your kids to be 80 by the time they get that last payment from the trust. Trusts after 2 years become taxable entities, all right, and it's at a high tax bracket, okay, so we don't want that. And we don't want to complicate the trust with all kinds of burdensome things, because if you're gone, someone else is having to administer those. Okay, I'll give you an example. Some people might say, my little kids are behaving themselves now, but I'll tell you what, if they start doing drugs, I don't want them having that money. Well, I understand the intent. But if you say they have to drug test, they have to be clean for 6 months, they have to do this and this before they get any money, think of the burden now you're putting on that successor trustee to carry that out. And how often does that have to take place? And think about the friction that you're now putting in place. So our suggestion, I'm not sure I'm still answering your question, but try and keep it simple. Okay? It's like with life in general, right? But with a trust, we want to keep it as simple as possible. Okay? I'll take a couple more questions and then we'll wrap it up. Yes? Great question. So that successor trustee that is going to carry out our wishes when we're not here, do we keep it in the family or what should we do? Well, our son, it used to be my sister, was our successor trustee. Zach, my son, is now 23. 2 years ago, I'd have said there is no way that kid will ever be my successor trustee. He's really made some strides, and now he's our successor trustee. Don't have to keep it in the family. Some of you sitting there today are going, there's no way my kid, no way. Okay? Or no way my brother or sister would be my successor trustee. Some people go to a friend. Some people go to an outside organization. There are trust companies, we don't do this, but there are organizations who will administer your trust and keep it away from the kids potentially being involved with that. Is it easiest to have the immediate family? Typically, okay? And for most of us, handing out our estate is usually going to be a pretty simple process. But if you have a very complex state, lots of assets, it's a complex situation, you might want to consider an outside organization doing that. Typically, they're going to take around 2 to 4% of the estate value when you have passed. Okay? Yes? Yes. Is there a need to have a trust and a will? Yes. You will get if you do something with us, you'll get a revocable living trust, and each of you, if you're married, will get what's called a pour-over will. Why do we need a will if we have a trust? Well, we don't put potentially everything into the trust, or we forget to put something in the trust, or we just neglected to put something in the trust. Now we want that will to say, pour over those assets into the trust when we die so that they're in the trust. Now, it's not a safety net for everything. So what our suggestion is, never let those pour-over wills come into play if they don't have to. But I'll give you a quick example. We suggest you put your bank accounts, checking and savings, into the trust. If you keep one outside, because I only got $100 in it, I'm just going to keep that one in my name just because. I want to. And then you pass 20 years from now, you sell your home 20 years from now, and you take $200,000 in proceeds, let's say, and you just park it in that bank account just for a few days because we're going to do something with it, and you were to die, you now end up in probate because that account was still in your name. So our suggestion is put everything into the trust, but you still have that pour-over will just in case, or for some assets maybe that didn't get into the trust. Okay? One more. Yes? Yeah. Great question. So Can you name one person as kind of your go-to? They're going to, not only are they going to take care of the trust as our successor trustee, they're going to also care for our kids, and they're going to help me if I can't make my own medical decisions. Yeah, it's very common. Usually we have one or two people that are kind of that go-to, and the others are like, hey, I'm not sure I want them telling the docs to pull the plug, right? So yes, you can do that. Now, I'll say that, but some people like to have some separation. I'll give you a quick example, and back to your kids' example. The guardian and your successor trustee, some people like to have that arm's length, meaning one is in charge of the finances and one is in charge of the children. All right? Well, why might that matter? Well, again, there's no trust czar that's watching over this. You're putting people in place that you trust to carry this out. So you might want somebody that is in charge of the finances that gives the money monthly or as needed to that guardian that is now taking care of the kids. Because otherwise, that guardian, if they're in both positions, might think, well, another trip to Hawaii is a great idea. We just went 2 months ago, but we didn't get to Kauai. So let's just take that. So some people like to do that. Can you name the same person? Yes, most times it's fine, but some people like to have arm's length, okay? So to respect your time, I'm going to wrap. I'll stick around for a few minutes. Jared, did you want to close us up for something?